You will allow me to briefly speak about case management, which is one of the major issues raised by court users, and the issue of frequency of adjournments, many of which are avoidable. Frequent adjournments not only delay justice, but also contribute to growing public frustration and erode confidence in our courts. We meet at a time when the judiciary has been placed under heightened public scrutiny across the country. As we are all aware, concerns have been raised not only about the timelines and quality of our service delivery, but also about the integrity of a few within our ranks. We as judges find ourselves on trial and a public examination for how we manage cases and serve our court users, and regrettably, for renewed allegations of corruption in some court stations. This scrutiny is a moment of reckoning and an opportunity for deep reflection and reform. It compels us to reaffirm our commitment to the values of integrity and efficiency that are at the heart of our calling to serve justice to the public. It is for this reason that we are intensifying our focus on improving case management and ensuring that court users are not subjected to delays or administrative inefficiencies. As we grapple with these challenges, it is equally important that we look inward at how we as judges can leverage on technology to enhance the administration of justice. Technology offers us tools that can improve efficiency, transparency, and accessibility in our courtrooms. We have already seen significant strides through online filing and virtual hearings, which have made it possible to continue delivering justice even in the face of challenges such as the COVID-19 pandemic. We are also now rolling out transcription support to all our courts nationwide. But we must continue to innovate and find ways to integrate technology further in our work, not only to streamline processes, but also to improve access to justice for all, particularly the vulnerable and those in marginalized and remote areas. As a specialized court, ELRC has a central role in upholding the labor rights of workers, even in the face of economic downturns. It must balance competing rights and competing interests. The right of workers to fair remuneration and protection against unfair termination on the one hand, and the right of employers to reorganize for survival and economic viability on the other. Judges of this court are therefore called upon to interpret and apply labor laws in a manner that is sensitive to both economic realities and enduring constitutional imperatives to protect the dignity and the rights of workers as enshrined in Article 41 of the Constitution. I will also speak to the issue of integrity and anti-corruption efforts. Alongside issues of efficiency, we are also grappling with renewed allegations of corruption within some of our court stations. These are deeply concerning and we cannot ignore them. I want to state once again, unequivocally, the judiciary is a corruption-free zone. And as we all know, and we have pronounced it, in many of the forums and even in our framework, we have adopted a zero tolerance policy to corruption, and we are determined to enforce it without fear or favor. To reinforce our institutional integrity, we are rolling out court integrity committees across all court stations. These committees are designed as inclusive platforms for judges, judicial officers, advocates, representatives of Ethics and Anti-Corruption Commission, EACC, and other stakeholders to raise concerns, share observations, and collaborate in addressing unethical behavior.